Hello, everybody. My name is Dean Salita, and I'm here to give you a webinar today sponsored by the Schmidt Law Firm. It says new developments regarding workers' compensation, but we're really going to have an overview talk about workers' compensation. A little bit about myself. I've been practicing 24 years. I practice in the areas of workers' compensation and personal injury, and many lawyers either practice in the area of personal injury or workers' compensation. So I like to combine the two, and I actually speak on releases and the way these cases are settled together, because it's important that the workers' compensation matters and the personal injury matters oftentimes go together hand in hand, and the head needs to know what the tail's doing. I'm very pleased that Doug Schmidt asked me to do this. Doug and I have worked together for a long time. He frankly is one of the most knowledgeable attorneys in the system about medical research, the medical understanding of things. And every time we have a case together that's a personal injury workers' compensation case or a case that we work on together, I'm very honored to work with him. He's a very bright, capable man who really cares about his clients. So let's get started. First off, let me make sure I can move my screen here. Okay. I'm having a little technical issue. I'm going to get us started on the screen. There we go. That's me. It's a much better picture of me than I should be putting up there. The one thing which I will point out is I'm licensed in Minnesota, Wisconsin, U.S. District Court, and I'm also licensing myself in Iowa. They're very different workers' compensation systems. Presently, I'm the chair of the Minnesota Association for Justice Work Comp department, which means I'm kind of Papa Work Comp. I go to legislative meetings. I organize CLEs. Any members on my side, if they have questions or concerns, they come to me. So if anybody does have any questions, go back. That's my phone number. That's my email. I'm happy to answer any questions for you as well. Let's talk about workers' compensation. Workers' compensation is a no-fault system. It is governed by Statute 176. And what no-fault means is, similar to the No-Fault Act with personal injury, you can be jumping up and down on a table, and if you fall, in many circumstances, you're covered. Things can be your own fault, and you can be covered if you're in the course and scope of employment. That is the key, course and scope of employment. And over the last year or two, it's taken a little shift away from the plaintiff side, which is disturbing on our side. So there have been many cases at the Supreme Court, and you'll see the Dykoff case. Dykoff, and I hate to jump into law right away, but Dykoff is a case where a woman was walking across a factory floor and just fell. It was determined that she didn't fall from anything that was specifically work-related. She just happened to be at work. For years and years, it's been that basically if you're at work and you injure yourself, even if you're walking, that would have been compensable. It no longer is. It's become a fact-by-fact matter that if she fell just because she fell in at work, there has to be something substantial about the work environment or work that led to that injury. So there have been a ton of cases following the Dykoff case, and they're one by one, and we seem to be getting more and more denials from people. It tends to be slipping and falling cases that do that. So that's something that's a work in progress and remains to be seen. But generally, must be in the course and scope of employment. Let's talk about this, because chiropractors see this often. There are a couple different kinds of injuries that tend to lend themselves in front of a chiropractor. Now, the bottom one is occupational injuries, as you can see. And an occupational injury, and I do a lot of this work, is exposure. They're cancer cases. They're asbestosis mesothelioma, like you see all over the television ads. They're carbon dioxide poisoning. There are many different things that creep into a workplace that causes a disease, psychological injury, stuff like that. That's not what we're talking about. A specific injury is one that happens, I always use the joke, you bend over, you pick up the water cooler, and your back goes out. That's a specific injury. Something that happens on a specific day can be reported, and the pain starts right away. They're supposed to go to their supervisor, and we're going to talk about that in a minute, how this works. That's what happens. A Gillette injury, which we're going to talk about a little later, is repetitive trauma. And obviously, as chiropractors, you will often see that. It started off a lot with carpal tunnel, but carpenters, electrical workers, low backs, shoulders, hips, somebody that does the same work over and over, repetitive trauma is recognized. The reason it's called Gillette is because it was a Gillette, the gentleman's name was Gillette, and that's where the case got its name. Everybody always laughs, is that something to do with the Gillette company or shaving? No, it doesn't. I like this cartoon. It's timely. I have a few cartoons. The caption says, the next time you decide to lift someone's spirits, lift with your leg and not your back. In the course and scope is huge. Well, I hope Santa doesn't hurt himself this year. Here we go. Here's a Gillette injury. Gillette injury, as you can see, here's the definition. The term Gillette comes from the case, and it is repetitive trauma serious enough to disable an employee. Based on that case, a work comp injury is not limited to one distinct event. The court noted that in the course of one's ordinary duties, injuries may occur daily, which cause minimal damage, and the cumulative effect of which in the course and scope may be injurious or disabling. Okay? I gave some examples on the bottom. Assembly line, clerical secretary, construction, or other occupations involving repetitive activities, bending, stooping, twisting, lifting, everything you guys are all familiar with. That's huge. Now, I'm going to talk a little bit. I'm going to bounce around with a couple of things throughout this entire seminar that I find very important. They're practical tips. One, as a medical provider chiropractor, when you have a patient come into your office, I don't care, and you know this, you've been trained this, but we tend to get rote and people tend to get lawyers, doctors, chiropractors, we all do. You have to make sure the history you take down, especially with an injured worker, you know what the injured worker does. And I always use the example because I had a case 20-some years ago. A bus driver does not just drive a bus. A bus driver has to open and shut that door, which was heavy. They used to have to do that. They used to have to check the coins. They used to have to get up and help a little old lady up the stairs. They used to have to pick stuff up. A bus driver does not just drive a bus. In order for you all to get your bill paid and to justify why this is a Gillette injury, you need to have a good history of your patient as to what's what. And you need to take those notes down very legibly. I act as an arbitrator in no fault, and the conversations I have with judges over and over about cases are, if the notes are legible, the history's good, they will listen. If you don't take legible notes, they're unreadable, they don't correlate to what's going on, and you don't even know what your own client or patient does for a living, they're not going to believe your opinion. It's that simple. So, in speaking to that, a Gillette injury is something with repetitive trauma. So you need to put in your reports and you need to put in your anything you take down. If, for instance, if they were working on an assembly line, person worked on an assembly line, was putting together widgets. They put together 10 to 15 widgets an hour. They were moving at this pace. The total amount lifted, because each one was 2 to 5 pounds. The more information you have, the stronger that becomes. So the question is then, well, if it's a Gillette injury over time and we know what the person does, what's the injury date? Because injury date controls everything in workers' compensation. Well, as you can see under number 2, a Gillette injury was established when there was an ultimate breakdown. And the ultimate breakdown in that case was when there was lost time from work due to the Gillette injury. It then was broadened, and the broadening became the date of disablement. And that's a couple different things. The word ascertainable comes up under the statute a lot, and ascertainable means when somebody knows this happens. For instance, an ascertainable event, modification of job duties. Your patient comes in, and forgive me if I go back from patient-client. Your patient comes into your office and says, holy cow, I've been doing this lifting for 2 years. My elbow and my shoulder and my neck the last 2 weeks have just been killing me. Well, you can start to put a date on that. You can start to put an ascertainable time together. Then sometimes what happens is when the chiropractor or the doctor or the medical provider gives restrictions, that's the date. It's kind of a moving target, and frankly, sometimes it's up to the lawyer to determine what the best date of that is, because sometimes they'll come to our office late, the patient. Sometimes they don't understand the whole thing, but it's basically when the person first can ascertain they have an issue and or when they first seek medical treatment for it. Here we go. Here's a list continuing. The date of the employee initial medical attention. The date somebody gets sent for a scan and they get a real diagnosis. Hey, you have a herniated disc at L4-5. Next, when the employee's treating doctor determined it was work-related. That happens often. You know this as chiropractors. Somebody will be treating with you for 6 months and then they say, oh, yeah, I forgot to tell you about when I was rear-ended by that UPS truck 6 months ago. Or boy, I've been lifting barrels over and over and over. You know, it's amazing how that happens. Sometimes it's when the employee's symptoms have recurred after they've subsided, and sometimes when the employee sought regular medical care, even though the employee had no lost time. So before we get into what the benefits are, I wanted to clarify, because there are two main things that you as chiropractors see often. One is easy, a specific injury. I bent over, picked up the water cooler. The second are these Gillette injuries. And once again, know your history of the employee. Make sure it's documented well. And once it's documented well, make sure that you continue to talk to them about this. If and when you give restrictions, it's also important to know what the employee does for work, does for a living. So once again, a judge, and what I'm getting at with all of this is, eventually if a case is contested, it's going to be up to what the doctor says, the chiropractor says, as to what they understand, and the more knowledge they have, the more credible they are. Here we go. I think this is important. Your role as the patient's chiropractic doctor or medical provider, however you want to call it. Courts require an employee to prove specific work activities cause specific symptoms, okay? And I'm not giving you all the cases. It's a long history of case law. But the Minnesota Supreme Court held that an employee need only prove a causal connection. That's not casual. It's causal, meaning caused by. Don't mix up that word. Between his or her ordinary work and ensuing disability. The employee's testimony alone is not enough to establish the connection. The finding depends mainly on medical evidence, and the medical provider must have adequate foundation as the nature of the employee's work duties to determine if they're the employee's symptoms. Again, your documentation of your patient's work history is critical, because the employee can go and testify on the stand if they have to. Well, I told the chiropractor and they knew this, and if it's not in your records, they're in trouble, and that's where they come back to you and they're not happy. So make sure you address that with them right away. Now I'm going to give you an overview as to what a workers' compensation case is and how it practically happens, now that we've established for your purposes the difference in the two injuries. Generally, somebody hurts themselves, or they understand, like a Gillette injury, how they've hurt themselves and what they're doing. They come and seek medical treatment with you. The employer, not the employee, is responsible for filling out what's called a first report of injury. A first report of injury then gets sent from the employer to their workers' compensation insurance carrier, and or if they're self-insured, to whoever handles the risk for them. There are certain circumstances where companies aren't insured and the state may have to kick in, but we won't talk about that today. Understand there's almost always insurance for somebody because the state will be there. It then goes to the workers' compensation carrier's decision to say, yes, we will pick up and pay for this claim, or no, we won't. I get a lot of calls during that time because people want an answer right away. As you all know, getting paid, the insurance companies aren't waiting for our correspondence, and they're not going to, you call them at 9, at 9:15 it's taken care of. So here are the 4 benefits you're entitled to, and if it's an admitted claim, it's picked up, and these things are paid until they're fought. If it's denied, the employee is likely going to have to get an attorney because they're going to have medical evidence to show that this is work-related. Attach that medical evidence to what's called a claim petition. That gets filed with the state, and then the employer and insurer have to answer. So here we go. 4 big-ticket items. The first are medical benefits. That includes everything: chiropractic care, medical mileage, prescription costs, physical therapy, massage therapy, obviously surgery, doctor's care, medicine. Now, I could be here for 3 hours talking about this. Some things aren't covered. As you chiropractors know, unfortunately, you're going to see me use the word rotten later. The chiropractic law has gotten rotten towards chiropractors, and we keep fighting on our side to not do it, but chiropractic care is covered, and we're going to talk in a few minutes about the difference between an admitted claim and a denied claim. Second, now here's an important factor. I'm sorry I jumped around. Medical benefits, if this is an admitted claim, are covered for the rest of the employee's life, as long as a doctor says it's work-related. So if they're working for, and I always use Dairy Queen, I like Dairy Queen. If they're working for Dairy Queen and they're laid off and they still are having shoulder problems, neck problems as a result 3 years later, and you as a treating chiropractor or a doctor says, yes, I think their problem still is related, or the need for more care is related, there's no time limit on that if it's an admitted claim. Once a medical bill, chiropractic bill, a bill is paid, it becomes something that does not have a time limit on it. If it's a denied claim and there was a first report of injury filled out, the employee has 3 years to bring a claim. If not, I misspoke. If a first report of injury was not filled out, it's 6 years. If one was filled out, it's 3 years. I don't remember what I said there. But that's the deal. So it can be as early as 3 years, as long as 6 years. So medical is an important thing with an admitted claim. The second thing is wage loss benefits, and you will hear many different acronyms for this. TTD, TPD, PPD, there's all the P's and the T's and the D's, I like to say. The first is temporary total disability. That's a wage loss benefit, and that's when the employee is totally off work. They cannot work. They are expected at some point to be returned to work, but they're totally off work. Temporary partial is when they're partially off work, obviously, but partial means they're working half-time, or they're working for less pay, or they're working less days a week, or sometimes people have 2 jobs, and they can be working their full-time job, and then they can't work their second job. That's also temporary partial, and they are entitled to 2/3 of the difference between what they were making and what they end up making. So with temporary total, it's 2/3 of the difference completely off. Temporary partial is it's 2/3 of the difference between what they were making and what they are making. Permanent total disability is if an employee cannot work again. And that's because of their age, the restrictions or disability they have on them, the labor market, what they've done in the past, their educational background, a whole series of factors lend towards what permanent total disability is. Obviously, the longer people are working, the more interesting that case law has also gotten. There is a presumption in Minnesota that you're supposed to retire at 67. But many people, when I talk to my clients, are saying and testifying, hey, I was going to work until they carried me out of that place. That's an important thing. Permanent total disability is a medical and vocational issue. It's not just if you as a chiropractor say, I don't think this person can work anymore. There also has to be a QRC, and that's what we're getting towards on number 4, to say, no, vocationally they can't work anymore. They have to do job search, and they have to look and see what else is out there. So let's get to number 3, permanent partial disability. Now technically, this doesn't sound like wage loss when I describe it to you, but it falls under the wage loss category. That is the disability rating you give, and I have that coming up later in the discussion here as to where to find that. But you as the treating chiropractor will give the employee a rating for their neck, for their low back, for whatever their injury is, and you have a right to do that. Work comp does not pay for pain and suffering. They don't. They pay for loss of function, and sometimes things are triggered where there'll have to be a scan, there will have to be some type of testing. I don't know if any of you have looked at it or not, but I'm going to direct you later where to go to look for where the ratings are. We're working presently on trying, because it's been almost 20 years since the grid, if you have a 10% rating, it's worth X amount. Well, the grid hasn't changed in 20 years, and we've gone through a lot of inflation, so that's one of the things being negotiated. 4th, vocational rehab benefits, QRCs, and retraining. And part of what Doug wanted me to talk about, because they pop up on both cases, are functional capacity evaluation. QRC is a qualified rehabilitation consultant. The employee on an admitted claim has a right to pick their own. The insurance carriers often will pick for them. Your patient, my client, has a right to switch QRCs and pick their own. And obviously they don't want somebody who's anti-chiropractic, anti-massage therapy, trying to push them back to work. It's important to know because people obviously do have their biases. So we have people on our side we work with, and the insurance company has people on their side they work with. That QRC is to go with them to the doctor and chiropractic visits, although you as a chiropractor do not have to, and I recommend this, you meet with your patient on your own. The chiropractor can wait in the waiting room and come in with the patient after to discuss restrictions, needs, but obviously as a chiropractor you have a relationship, you have a fiduciary relationship with your patient, and they don't need to be in there monkeying around. There may be something that your patient wants to tell you confidentially, and they don't need, because the QRC is supposed to be neutral, them meddling in it. They can come in afterwards, and they're supposed to be neutral, trying to help with medical treatment, trying to help with getting bills paid on some level, trying to help with returns to work, but that's their job. They're really a liaison. Retraining fits under that as well. And retraining is a tough nut to crack these days because somebody has to have an exceptionally high wage. They have to be off work for a serious amount of time. They have to have they can't just be retrained right away. They have to look for work within their restrictions. And that's something we won't talk about too much, but let it be known that retraining is out there, and there aren't that many approved every year, but it is something out there. We talked about this a little bit, but we're going to talk about admitted versus denied claims. So if it's an admitted claim, those 4 benefits, medical, wage loss, the permanent partial disability rating, and the rehab are picked up. Chiropractic care has rotten limitations on that, even with an admitted claim. And you guys, we're going to talk about this a little bit. An admitted claim gets 12 weeks and the potential for 12 additional visits. And that's what you're stuck with the exception of some, as we're going to say, departures from that. And we'll go through the departures. As I said, I'm in charge of the work comp division, and I hear everything. Some people tell us and I don't know what the truth is, they're having a lot of luck with departures. Some are saying they're having no luck with departures. Part of it depends on the judge. Part of it obviously is case specific as to how strong the chiropractor has written what the departures are. But on a work comp case admitted claim, generally I would say more often than not, unfortunately, it's 12 weeks plus an additional 12 visits. So I always recommend to the chiropractors I work with or people to call that they should get them to a neurologist or get them to an orthopedist, somebody who's chiropractic friendly, to say that, yes, Dr. Chiropractor is helping, and this is why they're helping. This is unique in this sense. This is what we need to do. That's what that is. Now, with a denied claim, the fee schedule doesn't apply, and none of this applies. You can treat your patient, and obviously you're not getting paid. If you need to run it through health insurance or run it through some other provider, you can do that. But when the time comes, if the case settles or is tried, there's no limit on 12 weeks. You could have treated this individual 6, 8, 12 months. So it's strange that on an admitted claim you would be limited as chiropractors, and on a denied claim there's no limit on it. But that's the fact. So I always tell the chiropractors I work with on a claim, if you're willing to, let your bill float a little bit, obviously the bill may be different than on an admitted claim. All doctors, chiropractors included, have to abide by the treatment parameters. The treatment parameters are guidelines that have been put in place by the legislature for determining what is reasonable and necessary to cure and relieve the effects of the work injury. And once again, if you'll see, generally the parameters permit 12 weeks of passive care or treatment to cure or relieve the effects of a work-related injury. The work treatment parameters, I can't post them all here, but here's what they are. They're section 5221.6010 under the Minnesota rules. Remember, this is not a statute. These are rules, the parameters. 5221.6160 through 5221.6600, and they apply to all dates of injury and all providers. Now, let's get to the meat of this for you, the chiropractic world. 12 additional treatments over the course of a year on an admitted claim may be permitted. 1, if the employee is released to work or is permanently totally disabled, and additional passive treatment results in progressive improvement or maintenance of the functional status achieved during the initial 12 weeks of passive care. So you're getting them better and it's working, it's getting them back to work, or passive treatment cannot be given on a regularly scheduled basis. Okay? Some people are out of town. Some people, 12 weeks just doesn't work. Some people heal differently. Make sure you document. Once again, I'm going to go to documentation. Returning to work, helping them to return to work, feeling better, doing good. When my treatment, chiropractic treatments are helping in this way and this way. Don't just rubber stamp them. Don't boilerplate them. Be personal about this. It makes a difference. A doctor must document this plan to encourage the employee's independence from and decreased reliance on treatment. What this came from and what the legislature was really dealing with for all these years, was that when the early 70s, when chiropractic was let into the no-fault system in the chiropractic system, guess what happened? Billing became significantly more. And it wasn't documented the same way. And the golden goose was cooked a little bit, unfortunately, and there started to be more limitations as the businesses and the insurance carriers decided we can't spend all this money on chiropractic. Well, part of what that is, once again, goes towards documentation. You need a treatment plan. You always need a treatment plan in workers' compensation. You need to show, hey, I would like to give this 6 weeks, 12 weeks, 18 weeks, this treatment, this treatment, this treatment. Not just treat. Don't just put down your EMS, and don't just write down the roller table, and don't just tell them in your notes what you're doing. You're going to be billing for an initial visit or evaluation. Make sure in that evaluation you have your plan in there. Very important for this. Next, the employee must undergo active treatment modalities during this period in addition to passive care. That speaks for itself. An additional 12 weeks of passive care must not delay surgical intervention or an evaluation for chronic pain. That also speaks for itself. It's kind of interesting. It came from, a little bit more conservative, old-fashioned medical treatments. If they need surgery, we don't want to pay the chiropractor another 12 weeks if they're not helping. That's what I always hear from the other side. I don't necessarily buy that, because if the chiropractor is helping to maintain the employee and help keep them going, help keep them working until surgery, or most importantly, like you all know, try to relieve a little bit of pain for these poor people, well, that's what you're supposed to be doing. That's what you went to school for. And once again, the passive care is not to treat chronic pain syndrome. The biggest beef in the legislature and why this was changed to be so restrictive and rotten is that chiropractic care, they feel under the work comp system, is not for life. Total antithesis of everything you've gone to school for and everything maintenance-wise and everything. It's just not right, but it is what the law is, and until we get that changed, I'll talk to you off the record about who to vote for. Let's talk about the departures now. A departure from the passive treatment parameter may be appropriate. And let's go through these, because I get a frequent call as to, well, what's a departure? What do I need to do? It's actually kind of simple if you read the statute, and that's why I'm providing this. There's a documented complication in the medical condition. Something happens. Radicular pains get different. Something goes awry. Something off the beaten path happens. That's the first thing, and you have to document that. Next, if the prior treatment did not meet the accepted standards of practice. I'll be honest with you, I've never seen that asked for. I don't even know what that means. It didn't meet the accepted standards of practice if perhaps somebody is going to some other doctor or they were treating for something else, or I don't know. That one never seems to creep up. This is vitally important, where the treatment is necessary to assist the employee in the initial return to work, where the employee's work activities place stress on the body part affected by the work injury, and this goes hand in hand, where the there's an incapacitating exacerbation of the employee's condition. You know, as a treating chiropractor, you see that all the time. If you're helping get that employee back to work, making them functionable, that's what the work comp system wants. And the work activities are busting that up again. They're making it feel worse. They're not doing it. Then they come to you and you adjust them, you EMS, however you activate, however you do, and you're helping get back to work. That's a huge thing. Once again, ladies and gentlemen, document that. Document it, document it. And that goes again towards number 4, where there's an incapacitating exacerbation. They come in and they say, gosh, I don't know what happened. I was in the bathtub and I twisted and boy, I've been so good. Same thing. Even if it's not at work related, if something happens at home, if it can be linked up to your original injury, that's what does it. Okay. The rules also permit a departure when the treatment beats 2 of 3 of these criteria, and they must be documented again. You'll know it must be in the records. The employee's subjective complaints are progressively improving, as evidenced by documentation in the medical record of decreased distribution, frequency, and intensity. Once again, ladies and gentlemen, take good notes. Let's talk up and down on intensity and frequency. Next, the employee's objective clinical findings are progressively improving, as evidenced by documentation in the medical records of resolution or objectively measured improvement in physical signs. You're getting your patient better. And third thing, now we go back again, which the system works towards, the employee's functional status, their work status, especially vocational activity, is objectively improving as evidenced by documentation in the medical records, again in the medical records, or successive reports of workability of less restrictive limitations. Basically what these say is your treatment is helping them get back to work. It's helping them act as human beings again. It's helping them function better. But you can't just check the box, I did this, this, and this. And I'm going to get to that in a second here. Once again, rare cases. People argue this a lot, but I think what we just discussed is much easier. Finally, if the prescribed treatment does not fall into one of these exceptions, The Supreme Court has held that departure is warranted in those rare cases in which departure is necessary to attain treatment. Well, I mean, it's pretty clear. If you're helping the employee get back to work, you're helping them feel better, you're helping them do their job, you're helping them pick up their kids, you're helping them sleep better, you're helping them with range of motion. That's what it's about. Rare cases truly are rare cases, and they come up under goofy circumstances. Again, I'm going to repeat myself. Document, document, document. Here's why. You have to think when you're sitting in your office and it's 5 o'clock and it's time to go home, you want to go to your kid's soccer game. I get that. But you always have to think, and this is being very proactive for the chiropractic field, if you want to get paid and people are questioning you, you have to think, what I'm putting down, I'm putting down for a court. I'm putting down for a jury to determine. I'm putting down for a work comp judge to determine, an unemployment judge to determine, a Social Security judge to determine. What I'm writing down makes sense. If I were to give this to my 15-year-old and explain to them, this is why this person's off work, does it make sense? Always write down your notes with the thought that this is going to go in front of somebody else to determine whether what you've done makes sense. Judges like to see detail. They want to know the provider can support their patient. They want to know they know what they do for a living. They want to know their history. And once again, I've told you I act as a judge and an arbitrator. Legible notes. I can't tell you how many times I've been an arbitrator where somebody's come in and testified, yes, I had this, this, and this, and I can't read notes. It's hard to award benefits when you can't tell what the benefits are. Okay, here we go. Most important, pay attention, everybody. How does the good guy get paid here? The Minnesota Work Comp Statute entitled an injured employee to reasonable and necessary. Those are key. The treatment has to be reasonable and necessary and causally related. It falls under 176.135, where you'll notice, thank goodness, psychological, chiropractic, podiatric, surgical, hospital, all treatment. There's nothing separate for chiropractic. It's under the general fare. There are two things. There is the fee schedule. The fee schedule is as follows. I explain this to my clients. And I always use the emergency room because it's easier than chiropractic. The emergency room can charge $1,000 for an emergency room visit. Somebody breaks their arm, you go in and work comp. Well, the fee schedule may say that only gets paid $450. Okay, that's it. We're done. The hospital gets $450. The remainder of the $550 goes away. The hospital can't chase the patient around for it. That's part of workers' comp. That's the same for chiropractic care. You have to know what your fee schedule is because, and there are programs for it. I'm not the one to go through that today, but you'll notice I included Minnesota Rule 5221.4060, our chiropractic procedure codes. I also recommend and always talk to all the chiropractors I know. Ask some other chiropractors that know this. Don't reinvent the wheel. Talk to them about billing. Talk to them about how they do it, what's successful, what's not. Chiropractors need to work together on that to see how that works. Once again, what is reasonable and necessary along those lines? The question whether chiropractic care is reasonable and necessary, and these cases, Horst was the case almost 25 years ago, which talked about this. Chiropractic care is reasonable and necessary when it's more than whether the employee experiences temporary relief. The court has identified factors. I have the cases here, but the treatment has to be reasonable and necessary and not cause temporary relief. So here we go. Ready? 1, there has to be evidence, again, of a reasonable treatment program, showing what the frequency and duration of treatment is, showing treatment on an as-needs basis instead of a set schedule, and the degree of duration or relief. You want to tell people how that's going to happen. Appropriate referral to other providers, the effect on treatment and the employee's employability. Once again, everything we've talked about getting bills paid. If you have to refer to a neurologist, have it looked at. If you need to scan, if you have the effective treatment, your effective treatment has helped them get back to work. Once again, 4, and this is looked at, I always tell people, don't kid yourself, the cost and treatment of the relief provided. And you don't need me to tell you, a lawyer, even though I have relatives that are chiropractors and friends that are chiropractors, if you're treating somebody every day for a month, nobody's going to like that. It's just what it is. Whether it's right or wrong, that is what it is. So you have to be aware of the cost of treatment in light of the relief provided. Here we go. Again, I want to point this out. make sure your writing is legible. Your notes are legible and thorough, especially on history and what treatment you've given. I like this. Diet and exercise, beer and pizza. What do you think about this? I've had some notes like this where I'm an arbitrator, where I'm trying to represent a patient. That's a real note. That doesn't work. You can't say that. Type it up. Add to it. Once again, no, 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 no. Insurance companies, read your notes. Your patient's going to be happy if when they come back to you and they say, you didn't tell this, you can say, look, I explained this. It correlates your diagrams to the history. Right shoulder, I got hit on the right shoulder. My low back hurt. It went down my left leg. You understand that. It's more professional. Once again, judges will be able to read. The judges will be able to read that. Those are the ultimate people deciding what your bill is. Now, let's keep on going on this. I'm not going to talk in detail about the permanent partial disability schedules. If anybody has any questions or concerns, you can always talk to me about them. I'm happy to do it. They can be a little confusing. They were not written by doctors. They were not written by chiropractors generally. But obviously what you see most as a chiropractor is spinal injuries that are dealt with. Of course, there's other injuries. There's carpal tunnels. There's epicondylitis. There's head injuries. There's, you name it. You see all of it and you treat all of it. But with the work comp system, what you generally will see is what the ratings are. Now, if you look on the bottom, and I had to cut and paste this, the rules are found up top there, the Minnesota rules. There, once again, it may be worth getting a rule book or calling the Department of Labor and Industry so you have one of these rule books in your office. But it's 5223.0370 is the cervical spine, 5223.0380 is the thoracic spine, and .0390 is the lumbar spine. I always tell people, because it's too hard for me to explain, it's basically loss of function. If you as a chiropractor have a question about it, look over those PPD rules and see what your knowledge of them is, what you understand, what you don't understand. Like I said, they're not always worded so well, so they're not always the easiest thing to comprehend, but that's very important. That is the call I get daily in my workers' compensation practices. I don't get paid pain and suffering in a work comp case. Nope. It's the disability rating. So this becomes important to people, and generally it's not a significant amount of money. So it's important to look through. You will get, oftentimes, which you probably get more often than not, a narrative request from a lawyer, if they have a lawyer on, where they want you to ask questions. If the lawyer is very helpful, they will include the schedule they're looking for in the letter to you to say, where does it fit under the schedule, so you have an idea. If you have a question, call the lawyer, ask the lawyer. But try to obviously fit in the guidelines that you have. This is not an AMA guideline. This is not just saying it's a permanent injury like it is in the no-fault system. It is a specific rating, so go to those. The other thing you'll get, besides a request for a narrative report, is something called a healthcare provider report. And a healthcare provider report is a form under the statute that can be sent to a medical provider where you have to fill out and check the boxes. One, no doctor is supposed to charge for that. It's not like a narrative. So oftentimes work comp lawyers will send these because they want to check the box. Have they reached their maximum medical improvement, which is a medical term? You know, have they plateaued in how good they're going to get? What's the disability rating? There's a little box. Is this work related? What are the diagnoses? You can fill that out and include your permanent disability rating in that as well. I'll keep moving because I want to make sure I cover everything time-wise. This is my favorite. I love these chiropractic cartoons. And this is my dad, by the way. I've diagnosed myself on the internet. I'm only here for a second opinion. How many of your patients have you seen that? I think I have blown disc. I think I have this. And they say, well, you know what? Why don't you let the chiropractic expertise kick in just a little bit? I do want to talk about this a little bit. A functional capacity evaluation. It's actually getting battled a little bit. I have one right now in a case that was resolved. Functional capacity evaluation truly is about returning an employee to work. And it's a hybrid in some ways. The doctor has to sign off, the chiropractor has to sign off if they're treating, on what the restrictions are and what the employee is capable of doing for work. But the testing itself is truly vocational testing, not medical testing. So recently this has come into question as to, well, are we paying this under the vocational part or the medical part, and what is it? And the big issue, which you will see occasionally, is when the QRC gets involved or the work comp carrier gets involved and you're one of the main treaters or the main treater, hey, we want to see what this guy's restrictions are getting him back to work. Maybe not given by you yet. Maybe you don't think the person's ripe to go back. Well, they're not legally necessary, but they're helpful to show limitations, and sometimes your clients will go through this. Now, there are some functional capacity evaluators out there who basically would say that every employee can go play for the Vikings right now, which maybe they can. There are some who will say they can't work at all. But there's middle grounds on that too, and I don't want to comment on it. But a functional capacity evaluation deals with the issue that giving restrictions and trying to help somebody get back to work is part of this whole bigger picture of what are you trying to do to get the employee back to work? How is your treatment as a chiropractor helping them get back to work? So the more knowledge you have, or the more arrows in your quiver, as they say, it just makes you look with more foundation. Now, I'm kind of proud of this. My office, years ago, in a couple cases, were the ones at the Supreme Court which determined that, you really don't need written medical restrictions to be disabled or to get wage loss, as long as they have a disability, because there are some times where an employee will come to you and say, I don't need any restrictions. I got to go back to work. I got to feed my family. I need my job. It's always important to note that in your restrictions too, that, hey, the employee came to me and said this, and said, with the job at hand, I'm going to let him determine or her determine what their own restrictions are. That's important, because sometimes employers will have blanket edicts that we're not getting this person back to work if they have any restrictions, and the job is more important to the employee than just the restrictions. That's a huge thing. We as lawyers have to fight then, well, if the employee lifted his own restrictions and is not restricted, they don't get wage loss. We got them back to work within that. Well, if they're laid off and go down the road somewhere and there's a new job and that job doesn't follow those restrictions, the employee can go back and have more limitations or restrictions put on. Restrictions are not necessary, but they're helpful, as is the functional capacity evaluation. And generally how it will work is you as the chiropractor will refer, or a doctor will refer for a functional capacity evaluation. It has to be approved if it's in mid-claim by the work comp carrier, and sometimes they like that, sometimes they don't. There's the case. It's Flayton versus Cole, and there was another one, Brenning, that followed. You'll see. Written restrictions from a doctor are not necessary for a comp judge to determine that an employee has continuing limitations in the ability. Once again, ladies and gentlemen, it goes back to your notes and the disability part of it. Now I'm going to jump around the last 15 minutes and talk about a few other topics, because obviously we're trying to cover as much as we can. There are not many lawyers that do, frankly, what I do, and I'm not patting myself on the back. Many lawyers just do motor vehicle collisions. Many lawyers just do workers' compensation. I happen to do both. They're very tied, and like many of you have probably learned in dealing with, who gets paid. They were in a car accident. They get work comp. Basically, here's what it is. Work comp is always primary. Work comp pays first, pays the 12 weeks and 12 visits if they have to. Once again, if it's denied, you can treat however. Benefits denied by a work comp carrier, or when you go beyond that, should be immediately sent to the no-fault carrier, along with a copy of Raymond. Now, I put Raymond in there in case any of you want to know. That's a case which basically says that once the workers' compensation is used up, no-fault has a duty to pay. It's a contract, okay? No-fault doesn't pay first. If work comp denies, that's where no-fault can pay, and we're going to get into my final topic's intervention. But once again, if anybody else pays a medical benefit, including you have an outstanding balance, you have to intervene in the workers' compensation action. So let's just say work comp carrier denies and State Farm ends up paying the bills. Well, look at it from State Farm's point of view. They're saying, hey, Mr. Salita, you're trying to prove your client has a work-related injury. We paid all the medical bills. It should be the work comp carrier that pays. And then they get involved in my action. They have to intervene, okay? Even if the no-fault carrier denies payment, the worker can file an arbitration. So let's say you get 12 weeks and 12 additional visits, and there's more of your bill out there, and it's a work comp case, and the carrier, the no-fault carrier then says, well, you got it all, and we don't think this is related. You can arbitrate the remainder of that bill. And once again, I'm covering a lot of topics quickly here, but basically that's the understanding. Work comp pays first. If there's no fault out there, no fault does potentially have to pay at some point. This is huge. If an employee settles their workers' compensation case and closes out which they were asked to do often. We fight this all the time, but we're asked to do this as lawyers. Well, because we're 8 months in and it's an admitted claim, there's no more chiropractic to be had there. Dean, your client should close out chiropractic and massage and certain things. And some clients want to, some don't. But if they settle the workers' compensation matter, and the workers' compensation matter has a closure of chiropractic care, they are not allowed to go then and collect anything under the No Fault Act. That is solid law, unfortunately. Because what the court said is, hey, this isn't just the work comp ran out and then you went to the no fault. You settled. You had a contract to close anything out, and that's under the statute, and had the no fault paid, they would have had a right to come back against the work comp carrier, and that's closed. Done. So patients should understand, and you should understand, that if they have a work comp case first and they settle the work comp case, they're done with no fault. There's no more payments to you either. So be wary of that. Once again, I like this. If it weren't for the headrest, I'd have serious whiplash by now. Let's talk about intervention. We're going to wrap up a little bit on a few topics. And then if anybody does have any questions, I'm happy to answer them. You can type it in there and I'll be happy to do it, but we have about 10 minutes left. This is the question I get more than any of my workers' compensation, the chiropractors I work with. And I'm going to tell you it from the employee's attorney point of view, because this has been the bane of our existence as well, and the law has changed in the last 2 years. It was changed by a case that went to the Supreme Court, and then it was redone by the legislature. It's been such a mess, I can't tell you. When I have an admitted claim representing a patient, obviously, they just pay. They pay you. We fight over whether there's more. We can file a medical request to do that. But if it's denied and my patient client is treating with you, I have a duty. I have to put you on notice pursuant to the intervention statute. And different lawyers do the same thing. I was part of the one that drafted some of this, so I have a good copy of it. And what that means is you then, as a chiropractic office, have a right to intervene. I call it more of a duty to intervene. And that means you have to file some paperwork with the department, put everybody on notice, and say, yes, my bill right now is $4,000. I want to intervene. Judge Judy, I want you to order that I'm part of this case. If you file that intervention, the lawyers and the parties cannot settle around you, with one exception, but we'll get to that. They have to include you as part of that. So your employee can't just say, I'm taking the money and running, I don't care about the chiropractor. The judges will not sign off, and they will not exclude you if you have intervened properly. Protect yourself, people. It's a form. If anybody needs forms, they can get it from me. You can get it from other chiropractors. You can get it from lawyers you work with. You can do it checking the box. We want to intervene, basically, but it must be served and filed correctly. To me, because I know some chiropractors complain to me about it, I didn't write the law, don't look at me, I just got to put you on notice, don't shoot the bad guy. It's just like sending a bill to Blue Cross Blue Shield or Medicare or anything else. It's one more piece of paper and it protects you. Then you can keep in your file when you start getting notices when settlement conferences are. You'll have knowledge as to what's going on in the file and know there's something going on. What happened previously is interveners, and it was many chiropractors and providers, weren't showing. They were relying on me, the plaintiff's lawyer, to show up and put all their bills in. But the intervention statute previously, up till 2 years ago, said, no. The intervener has to show up. Well, it wasn't happening practically. It just didn't happen. The courtrooms don't have room for 20 people every day. Chiropractors, doctors, Naran Clinic didn't want to send Bruce, the guy who works there, or somebody down every week to sit there 5 days a week. It just wasn't working. Well, the Supreme Court, who didn't really understand the practical part of this, said, no. If they're not there, they're extinguished. So there was a rush from the insurance company side to say, nobody's showing up. Chiropractors, we're going to extinguish their rights right away. And if they haven't intervened and they haven't shown up, forget it, they're done. Well, the chief judge, who I have a lot of respect for and really like and is very even-handed, said, no. We're going to start to call people and we're going to try to set, and she set up a whole system that was in place for about a year. And then the legislature changed and went and redid the whole thing anyways and said, hey, they don't have to be there, but they have to intervene properly. If they don't intervene, they don't file that paperwork, they can be extinguished. It's not about showing up, because there are mistakes that happen and people don't always show up all the time, but it means that you as a chiropractic office have to take the time to fill out a response to that intervention statute. If you want to read the statute, that's what it is. Here's a little part of that. Interveners do not have an independent right to bring a claim for reimbursement against the work comp carrier. They, meaning you guys, can't file a claim petition, which is what I have to file and the employee has to file within the work comp system. But they can become a party after the litigation and petition is filed. Well, that makes no sense, does it? You know, we've had an issue down at the Department of Labor and Industry where a chiropractor referred somebody to an attorney and said, hey, my guy needs help. The chiropractic bill is still outstanding, and I'd like to pursue this. Well, the attorney can pursue it on their behalf, but the chiropractic office doesn't have a right to do that. The Department of Labor was a little bent out of shape about this, said, well, they can't just do this. They can't push litigation. And it turned out it kind of went away. It was a strange issue. Basically, if you have an outstanding bill, you want to get your bill paid, and it's not getting paid by the carrier, believe it or not, you can't file that on your own. You need to contact an attorney, have your patient contact an attorney, because you can't even file it on your behalf. The patient has to hire somebody to do it. Now, the practical part is, so how does the attorney get paid? Because those people don't want to do it just to get you paid. It's called a RORAF fee. That was, once again, the name of the case. I get paid my hourly time or a percentage of the bill directly by the insurance carrier to help get that bill taken care of. So what happens is, I file a medical request or I file something, and the chiropractor has to have still intervened at that point. So anytime you get a notice of this intervention, you have to respond. That is your way as a chiropractor into the system. And once you're in the system, they are not supposed to settle around you. Let's assume they do. It happens occasionally. A judge misses somebody. The department misses something. It's settled around, even if it's not intentional. If you have intervened, you have a right to get back involved. If you haven't, you're done. And it's next to impossible to open up after the fact. My office still does that. I'll still try to say, even if something is missed, and it's happened less than a handful of times over the last 25 years. I'd say 2 or 3 times. But we end up trying to work something out with the insurance carrier, but you don't want to be putting yourself in that circumstance. You just don't want to. You want to intervene, and you want to be done properly. And you want to check in with lawyers aren't always good at phone calls, returning phone calls. I don't know if you guys have noticed that, but it is good to check in once in a while and say, hey, just curious to know the status, or shoot an email, or shoot a letter. The majority of our days as lawyers is spent on the phone. I will go through, as much as you will see patients, I will go through 40 or 50 phone calls a day where I'm at my desk and I'm talking to people, because that's what I pride myself on. I pride myself as best I can on talking to my clients, talking to people, keeping them updated. But obviously it can get overwhelming. That's why it's important for you, when you get overwhelmed, to make sure those intervention paperwork is filed. Now, there is one way that parties can settle around an intervener and the chiropractor. And if it's the number, and this happens occasionally, if the settlement number is just too good for the employee, and I as a lawyer have to give advice to say, hey, this is really a good settlement, but they're offering you, the chiropractor, 25 cents on the dollar. They're offering you 10 cents on the dollar, making you go away. Well, remember, even if you refer somebody to a lawyer, they don't represent you. They represent the employee. They will likely, if they're doing their job well, protect your interest and fight for you. But there are times it does become a conflict for us as a lawyer where we have to listen to our client. And if they say, no, I want to take the money, and the chiropractor is standing in the way of that, there's a case out there that was called Parker-Lindbergh. There's a thing called a Parker-Lindbergh hearing, where the case will be settled around the intervener who doesn't want to participate or doesn't feel that their interest is, being met satisfactorily. Then what you have a right to do as the chiropractor is hire a lawyer, which you can obviously work out whatever fee arrangement you want with them, and they have to prove your client's claim and that the treatment was reasonable and necessary. And it could go to a hearing just on your bill to determine reasonableness, necessity, causation. It's like having the whole case tried just over your bill. And generally, the employee will be helpful about that, because that's how that goes. I have about 2-3 minutes left, but I really wanted to cover that intervention significantly. The workers' compensation system is a very complicated system. It's statutorily run. It all runs by the statute. There's not as much creativity in personal injury cases. There's not as much wiggle room. It kind of is what it is. The most important thing is, obviously, Documentation. Once again, I put this up here. Your most important thing as a chiropractor, and I say this from acting as a judge, is legible notes, knowing your patient's work, not just rubber stamping every time they come in, checking the same thing. Make each note a little different. Make each note a little personal. Add something in even about their personal life if you want, just a little bit. You know, they celebrated their birthday, they this. When I'm reading that as a judge, I'm thinking, boy, this chiropractor didn't just punch it in. They really know this patient. They must really be caring and they must be doing that. And then if your notes read like Chinese or hieroglyphs, you got no support for it. That's this right here. Make sure your notes don't look like this. This is your postcard to the world. And this is what you're telling the world if you don't come in and testify what you did. So it better be dang well articulate and written well. They are kind of, aren't they? We're still fighting this battle all these years later, both lawyers on the petitioner side and chiropractors and some physical therapists and all the beautiful holistic medicine that's out there is fighting for legitimacy. Whether what's going on politically with Obamacare, whether it's changes in the statute, whether it's changes in the legislature, I like this. Whiplash cases can be a pain in the neck. Chiropractic care, like you know, it's getting old fighting for your existence. You guys don't need to be justifying your existence in doing this. The most thanks you get and the most wonderful things you get are like I get notes saying thank you from my patients. When you know you've helped somebody and you know you've done that, that's the most rewarding part of your job. And that's to me why I like working with chiropractors. I like fighting for bills. I like trying to articulate the medical to some of the judges because sometimes they get bored with this and don't understand. Once again, I'll sign off with this unless somebody has a question, and I'll wait a minute or two because we're supposed to sign off now in about a minute, is make sure your notes are legible. Make sure you understand the history of how your patient hurt themselves. Your client, make sure it's in writing. Get involved in the case. If you get an intervention notice, don't ignore it. Answer. Call somebody. Call me. Call the Department of Labor. They will explain to you what to do. There are forms online at the Department of Labor and Industry. There's many resources out there to do. I thank you. I'm sorry if I spoke fast. I had a lot of, I could have talked about this for a week. I had a lot of topics to cover and tried to make sure that some of these developments out there, but in order to understand the developments, you have to understand that the basic premise of the law. So if anybody has any questions, I'll wait about a minute, but thank you for listening again. I'd also like to thank Mr. Schmidt and the Schmidt Law Firm for asking me to do this. I'm very flattered. I do a lot of work with him, and he's really a wonderful man and very supportive of chiropractic as well. Thank you.